that. Now let's go.
Well, it was my understanding that the court indicated to me previously that you wanted me to testify. I understand you've now changed your mind. I think it's a good idea if I do it. Where would you like me?
Okay.
Do you want me here at the podium?
No, on the
Okay,
list.
sure.
She wanted it on the record. That's what she said.
All right, Ms.
Prior-
Morrissey
prior to this, she
voluntarily
stated
calling
what she
herself
went
as
on
a
the record.
witness without any requirement by the court to do so, or Mr. Spiro asking her to. Please raise your right hand.
Man, they
You
slick,
swear
man.
affirm under penalty of law that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Go ahead.
During my investigation of this case and my review of the evidence in this case, I came to understand that there was a large batch of live ammunition that was in the possession of Thel Reed, Hannah Gutierrez's father. I also understood from all of the evidence and testimony that a portion of that batch of ammunition that belonged to Thel Reed was taken by Thel Reed and Seth Kinney to the 1883 Cowboy Training Camp. When that was over, leftover ammunition was taken back to PDQ Props. Seth Kinney took some of the ammunition from that container that he had brought back from Texas and turned it into the sheriff's department. And it appeared to me that he did it to try to exonerate himself. They took it from Mr. Kinney and they tagged it into evidence under the Rust case. Law enforcement then executed a search warrant at PDQ Props and they took the entire container. And I will say that I do agree, as I recall, although I don't have it in front of me, I do agree that the search warrant didn't really require law enforcement to take everything, but it was my understanding that Mr. Kinney gave them everything so that they would have it and could tag it into evidence. Portions of that ammunition were then sent to the FBI for testing so that they could be compared to the live rounds that were found on the set of Rust. The FBI testing demonstrated that the live rounds that were taken from PDQ Props that were originally in Texas did not match the live rounds on the set of Rust. And that's testimony that we heard during the Gutierrez trial. So what ended up happening was Mr. Bowles, Ms. Gutierrez's lawyer, put Mr. Teskey on a witness list and was intending to call him as a witness to the Gutierrez trial. I conducted a pretrial interview of Mr. Teskey, and I want to back up. I did at this point have some understanding that Mr. Teskey had had contact with law enforcement.
Look at everybody looking at her
regarding
like
these rounds that he still had in Arizona. So these are rounds that never left Arizona. They were always in the possession of Thel Reed and Troy Teskey. They never went to Texas. They never came to New Mexico. That's what all of the evidence indicated. So I understood
bingo
that Detective Hancock
you
had
cannot
communication with Mr. Teskey about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teskey. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico. And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value. Then, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust. We then cut to November of 2023. Mr. Bowles has put Mr. Teskey on a witness list for the Hannah Gutierrez case. We conducted a pretrial interview with Mr. Teskey on November 2nd of 2023. At that point in time, he brought up that he was still in possession of these live rounds that were Thel Reed's live rounds that had never left the state of Arizona. I then, when he started, I think he indicated during the pretrial interview that they were from the same batch that was sourced from Joe Swanson. And I then said, we should get those from you. I had a conversation with Detective Hancock after that pretrial interview about how we could get the rounds from Mr. Teskey, and we were trying to figure out if we could send a local law enforcement agency to pick them up. I was then decided that I needed to figure out if that was necessary, since they had never left Arizona. And up to that point, it was my impression that they did not match the live rounds from the set of Rust. I then, as I recall, reached out to Mr. Bowles. He and I had a conversation about whether or not the rounds should be tested by the FBI. And I was still trying to figure out if I could get the rounds from Arizona to New Mexico. So I asked Mr. Bowles to please send me a photograph of the rounds from Troy Teskey so that I could see with my eyes whether they were even remotely similar. If they were similar, I could go through the steps of obtaining the ammunition, connecting probably with local law enforcement, having a local law enforcement agency go to Mr. Teskey's residence and collect them. I didn't want to do that if they didn't look anything like the rounds from the set of Rust, because all 6 rounds from the set of Rust are identical to each other. So when I had this conversation with Mr. Bowles, he provided me the photograph that I showed this morning. And this is it was my understanding that this was a photograph from Troy Teskey. So Troy and I don't communicate. He's a defense witness. I can't communicate with a defense witness. So Mr. Bowles, as I recall, texted me this photo, and this is a photo that Mr. Teskey took at my request so that I could determine whether this ammunition was related in any way to the set of Rust, because it never left the state of Arizona. So if it never left the state of Arizona, the only way that it is relevant to the Rust investigation is if it has any similarity to the live rounds that were found on the set of Rust, because we were at that point trying to figure out the source of the live rounds. When I received this photograph from Mr. Bowles, I could immediately tell that these are very dissimilar from the live rounds that were found on the set of Rust. They have brass primers. So this is what was presented to the prosecution as the rounds that were in Mr. Teskey's possession. They have brass primers and not silver primers. One of them, the one on the left, appears to be a Starline brass casing, but they have truncated cone projectiles. We had seen ammunition that looked exactly like this, not exactly, but very, very similar. And that ammunition was the ammunition that was collected from the sheriff's department and went to the FBI for testing and was determined not to be similar in any way to the live rounds on the set of Rust. So when I saw this photograph, I could see that it was not at all similar to the live rounds on the set of Rust. And I decided not to take any steps to collect this ammunition because it was in Arizona, had never come to New Mexico, and didn't match the live rounds on the set of Rust. So what ends up happening is Mr. Teskey is called to New Mexico by Mr. Bowles to testify at the Gutierrez trial. And you can hear on the video that the court heard Mr. Teskey say, the defense attorney, that's not me, asked him to bring samples of that ammunition. According to Mr. Teskey, he brought the samples of the ammunition, showed them to the defense attorney, and the defense attorney said, I don't want those. I'm not going to use those. And by the way, I'm not going to call you as a witness. So Mr. Teskey sat in court during the trial, and then at some point contacted the deputies downstairs and said, I have this ammunition. So he tried to give it to the defense attorney, who's the person who asked him to bring it. The defense attorney said no. And he then tried to get a hold of Detective Hancock, who was not available because she was with me. So then he ends up going to the sheriff's department and he leaves the ammunition at the sheriff's department. I was contacted, I don't think it was the same day, but I'm not 100% sure. It's possible that it was, by Detective Hancock, and she indicated that Troy Teskey had dropped off ammunition at the sheriff's department. Because I had already asked for a photograph of it, I believed that that ammunition was going to look like the photograph that Mr. Bowles had sent me. Corporal Hancock indicated that she was going to tag them into evidence and she was going to create what she called a doc report. And I said, great, do that. I was not aware at that point in time that a doc report would not have the same case number as Rust. I was not aware at that point in time that it would not be linked to the Rust case number. I understood that he had dropped off ammunition that I believed to not look similar to the ammunition from the set of Rust. And I had no idea that it wasn't going to have the same case number.
Clearly.
I want to show the court, though.
Yeah, clearly.
When Mr. Teskey showed up to testify with the ammunition that Mr. Bowles told him to bring to the state of New Mexico, he was not called as a witness, and Mr. Bowles said, I'm not taking that ammunition from you. That's why. Because these are photographs from Hannah Gutierrez's cell phone extraction, and they show spot-on match for the live rounds found on the set of Rust. This is clearly the reason that Mr. Bowles said, you and your ammunition better get out of here, because it would not have hurt the case, the state's case against Hannah Gutierrez. It would have been the best evidence I could have hoped for. These look exactly like the ammunition, the actual ammunition that we have in evidence. And they do look like the 3 rounds that are in that envelope. So when Mr. Teskey couldn't get Mr. Bowles to take them because they were the best evidence against his client, he took them over to the sheriff's department. And when he dropped them at the sheriff's department, I was told that there was going to be a report. There was a report. I assumed they looked like these. And Detective Hancock indicated to me that because he dropped them off and he didn't wait for her, she was then going to try to follow up with him, take a statement from him, so that we could get some idea where they came from, what the relevance was, if there was any relevance at all. And he never returned her phone calls. And that's all of the information that I can give the court, but I'm happy to answer any questions.
Let's go.
Can I ask a few questions, Ron? When you took over this case, the investigator handling the case, Mr. Schilling, left the case, correct?
At my request, yes.
The paralegal that was handling this case with you left the case, Mr. Tapp?
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union, that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Erlinda Johnson, the next prosecutor selected, resigned from the case today?
She did.
Want to hear how crazy this got? One of the lead prosecutors, not the one who took the stand, Morrissey, one of the other, the one who gave the opening statement, quit today. Why? Guess what? This almost never happens. This prosecutor wants to be heard enough that she's coming on TV right after this happened. Erlinda Ocampo Johnson joins us now. Thank you so much for taking the opportunity.
Hi, Chris.
First, let me give you a chance to respond what was said about you. Another member of the team said you left the team because you didn't like that this Brady hearing was public.
Absolutely not. Absolutely not. I left because I learned about this evidence when the public learned about it yesterday, late afternoon. As I don't know if you're aware, I actually came on this case kind of late in the game. I came on the case towards the end of April. So I had to get up to speed. I was not involved in the Hannah Gutierrez case at all. And so I was not aware that this individual had taken this ammunition to the sheriff's department and provided it to the officers. I learned all of that yesterday when Mr. Spiro was cross-examining the crime scene technician. So I inquired some more. And this morning, when the motion hearing began, my position was during the lunch hour, before the lunch hour, during the lunch hour, we have an obligation as prosecutors. We have an obligation not only to the people, but to the defendant.
Mm-hmm.
And our obligation is to make sure that all the evidence is turned over. We don't get to decide what the defense is going to be. Our job is to ensure transparency and to ensure that the defendant has everything that the prosecution has gathered. What they do with it, that's up to them. Go ahead.
Two things. One, the better minds that I bring on the show, because what do I know, were very impressed by your opening. They felt that you had good command and that you made a very strong case. Did you believe that Alec Baldwin should be found guilty?
I did. I believed the evidence that we had. I had no idea that there was this other evidence that had not been turned over. That there were some actions that were done during the filming, and there was some recklessness. I did based on the evidence that was available. But my job is not to get a conviction. It's to put the evidence before a jury. That's how I saw my job, is to put all this evidence before the jury and let the jury decide. But once things start, oh, go ahead. Sorry.
No, I want to hear you. But once things what?
So once I learned that this evidence was not turned over, that it was there, it was under a different case number, and my obligations, my ethical obligations as a prosecutor. Now, keep in mind, I've been a prosecutor. I was a state and federal prosecutor for over a decade. I've been a prosecutor. I've been a criminal defense lawyer for the last 16 years. So I've been on both sides, and I know what you're required to do. And when this came to light, I think that the best decision would have been for the state to dismiss the case. That's why I resigned.
Really?
Because I believed that case should have been dismissed. And I advocated for that over the lunch hour, and it wasn't. And so when we came back after the lunch hour, I asked to withdraw.
So you wanted the prosecution team to walk away from the case. They said no. So you said, then I'm walking away. And then the judge basically agreed with you. So I have two questions. First one is, so you believed it should be dismissed. Explain to people who don't understand anything about the law, why did you believe this ammunition was so important for the defense?
So obviously, you're a lawyer, I think. Brady versus Maryland imposes requirements on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well. So is the evidence material? That's number one. How timely is the disclosure? Without question, this was grossly untimely. Number two, is it material? So the question is, could the defense have made some use of this evidence in their defense? And like I said, we as prosecutors do not get to make that decision what the defense is going to be. It's, can the defense use this, and could it potentially raise some sort of reasonable doubt? And you have to step back. You're not an advocate. As a prosecutor, you're not an advocate. You are there to present the facts and to present the evidence. And your job is, and that's why I took this case on. I agreed to come on board, is because there was a woman who was killed. No question about it. This was tragic. And something happened. And a jury needed to make that decision. And so I believe in the system. And unfortunately, something went horribly wrong here, and I was not aware of it. And when I did become aware of it, my ethical obligations dictated that I advocate for a dismissal.
So let's talk about what went wrong, okay? And you guys at home can Google Brady versus Maryland. It's a 1963 case that basically just goes to things that either could be exculpatory, meaning it's evidence that the defense could use to show it wasn't them, or what they call impeachment, which is evidence that the defense could use to show that one of the witnesses for the prosecution is full of it. Okay, basically that's what Brady was. They call it Brady material. Your co-counsel says you have it wrong, that this ammunition, she knew about it, obviously, and she says, nah, it didn't have any real value. It had no resemblance to the ammunition that is involved in Alec Baldwin's case. Why would I turn it over?
Well, at the end of the day, a jury could have believed that, but our obligations are to turn all evidence over that could potentially be used by the defense in their defense. It's not for us to decide what is the defense going to be. It's not for us to say, well, his defense was he didn't pull the trigger. So his defense is not.
I got you. But here's the tough question. The suggestion, not from you, from me, is that this may have been in bad faith. Your co-counsel knew about this. She was willing to get on the stand, take the oath, and say, I didn't see any value here. Defense counsel and you echo the same standard. You don't get to decide whether or not it has value. She says, yes, I do. Otherwise, how do I know what to turn over? And I thought this didn't meet the standard. What is the standard, and why do you believe co-counsel got it wrong?
Well, this is a lot to process. Obviously, I learned about this yesterday evening. But just in looking at, so the first time I look at this evidence was this morning, because it was brought over to court. I think as you saw, the judge had them open the envelope. And so there were 3 rounds that looked very similar to the live rounds that were found on the set of Rust. Thinking as a defense attorney, I'm thinking the defense could have argued Hannah Gutierrez-Reed was a great armorer. She was completely competent, and there was sabotage. So you have that potential sabotage angle. So then at that point, potentially those 3 rounds do become potentially exculpatory. But the point is, it should have been turned over. It wasn't turned over. And
you think it met the standard? Any way you look at it, it should have been turned over. It was enough for you to step away. I want to ask you about the case now that it's dismissed, because I didn't understand why you guys brought it. I thought it was totally political. I thought if this guy's name wasn't Alec Baldwin, if it was Alec McIntosh, he wouldn't be there. That he pissed off the prosecutors early on by what he was saying, and they wanted to get him. Why am I wrong?
Well, first of all, I was not involved in the charging decisions. I will tell you that based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some horseplay with this gun. For example, one individual who was interviewed by the OSHA investigators and testified or gave an interview that there was a time that he allowed Mr. Baldwin to use him kind of as a target, to shoot blanks at him at his person. And obviously these are real guns. You don't do that with real guns. So there's
on a movie set? But isn't that exactly what they do on a movie set?
Well, no, you don't use another person as a target, as a human target. So that could potentially be reckless. And so, he wasn't charged with intentional homicide. There's no question, for me, there's no question Mr. Baldwin did not intend to do this. But the question is, was there wanton and recklessness? And so that's why I did believe in the case. I had no idea that this other evidence had not been turned over.
That is very clear. And I've told the audience, this is not about you. That's a separate prosecutor who seemed to know about it. We've showed her on screen. Her name is Morrissey. It is not you. I just want to ask you, I have 2 more questions. The first one is, I still don't buy it. I don't understand how on a movie set you should have a reasonable expectation that you might have live ammo in the weapon. But why? Why would you have that as a reasonable expectation?
That's actually
Because remember, there are the SAG guidelines. There's bulletins, safety bulletins that dictate even if you're an actor, even if you're on a movie set, you treat a real firearm as though it's always loaded, never point it at another person, and don't put your finger on the trigger until you're ready to shoot. Those are cardinal firearm handling safety rules. So yes, did I believe that there was some inappropriate behavior with regard to handling this gun? I do. It's unfortunate that things went the way they went, but the fact of the matter is that we as prosecutors have very, very serious and high ethical obligations that when something comes to our attention, evidence comes to us, or we become aware of evidence, you turn it over.
Based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that she didn't agree with the decision to have a public hearing.
Did you hear that? Ms. Johnson, special prosecutor, quit during the lunch break. Okay. Oh, I have the video for this. We're going to get into it. Let's go.
On July 1st in this matter, you served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time. I did not turn over the report. I didn't have a copy of the report. The rounds that were left at the Sheriff's Department by Troy Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Bell Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case.
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the Sheriff's Department. But you are right.
And you concede that they are Starline brass silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you've said that a couple of times. Any favorable evidence you understand as a prosecutor has to be turned over to the defense.
You said it a couple of times.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question.
She knew it was Brady. She knew it was
When the
Brady.
second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there, that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine. And that was provided immediately. I went back, I checked my email. I could see that I received it from Mr. Hague and failed to forward it on to be uploaded. And I provided it as soon as I was aware that you did not have it.
The fact that nobody at the Hannah Gutierrez retrial cross-examined Mr. Hague about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Hague at that trial that was inconsistent at least
Throw this
partially
chick
inconsistent,
away.
as the court's aware.
Throw
with
this
history of the
whole
court,
chick away, bro.
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this and you saw me go back and forth with Mr. Hague for 25 minutes. So
I agree, but I need to know what you're talking about for me to answer your question.
okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to.
You say that
If you can't answer the question, let's just move on because you got caught, man.
the extent of the communications you have about the doc report, as you relay it to the court, is that all you said in response was, great, do that? That's your testimony?
Yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up questions?
No, because I had a picture of the ammunition that didn't match the ammunition from the set of rust.
No concerns in your mind when you got the case file and you turned it over to us that it wasn't included?
Absolutely not. There's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that, I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
As I asked you about Mr. Hague yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you. And I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never tested those rounds either, correct?
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these. I've never seen these. And I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right. But don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, just so you know, I know about this. I knew about this then. I was involved.
I did not intend to mislead the court. My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the live rounds from the set of rust.
The truth of this matter is you don't like Mr. Baldwin very much, do you?
That is absolutely untrue. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a cocksucker.
I do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of rust. I don't recall saying that.
Do you deny that under oath?
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
You called him an arrogant prick to another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during the witness interview?
I don't believe I did. I don't recall.
You deny that?
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spiro, I want to give a full response to your question. I made every effort in this case to resolve this case with your client in a very favorable way for him.
All right, I'm going to move distracted. It's not responsive.
It is
Well, I don't
responsive.
want to talk about plea negotiations.
Yeah, and it's not responsive. So I have no further
All right, do you have any follow-up testimony? All
I,
right,
I want to say I have no recollection of calling him any of those names. I have invited the defendant to tell me what he's talking about, and he has declined. I want the court to take notice of that.
thank you. You may step down. All right, any other witnesses?
No, Your Honor.
All right, argument, let's not, 15
Wow,
minutes aside
man.
sufficient?
I don't even think that is necessary, frankly.
Do you wanna make argument?
Further argument.
All right.
I don't think he was citing further argument.
All right,
This is absolute facts, man. Jean say it's weird. She acts as though this evidence wasn't important to the defense. That's pre-law school. I don't recall are the famous words on the stand. Absolutely. Look, the fact that she act like this evidence was not key is just asinine to me. The fact that you are able to grab some live rounds from a different set and then transport them over to another set and mix them up with dummy rounds and then try to blame it on someone who has no knowledge of it at all is absolute madness. Absolute madness.
So dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatches, while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teske gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
I appreciate everybody that watched this live today, man. Let me know again what y'all think in the comments. Go ahead, like, share, subscribe to the channel. And I definitely want to make sure that I show all the love to my mods, man. I appreciate y'all holding it down. The mods from Cali, the mods from Maryland. I appreciate everybody so much, man. I thank you all for rocking with your boy. Hey, yo, until next time, it's your man, Tay Biz TV. I holla at you. Have a good day.
I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my baby. Know how I'm coming. And they know what we had. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. My young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With a boy, I'm so seen. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that Henny fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that Lily before I get crucified. Living in my bloodline, this place in my family tree. How the f they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty thick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there. Around through that left side, low end.